There are 6 specific documents that American homeowners over 60 should consider, yet many do not. Upon their passing, the absence of these forms can create significant financial burdens for their children, potentially jeopardizing the family home. I will guide you through each of these important documents. I'll explain the approximate dollar amount each one can save and the proper sequence for filing them. The 5th form we'll discuss is one that a large majority of seniors may not be aware of until their loved ones are in probate court, where a judge determines the fate of their parents' residence. We will address that specific document in a few minutes. First, it is essential to grasp the underlying reasons for this situation. The American probate system can be complex and costly, often resulting in substantial expenses for state courts and fees for the attorneys involved. Consequently, every year, thousands of American families experience financial losses, sometimes equivalent to the entire value of their home, because they were not informed about 6 key documents that could have prevented it. The cost to file most of these forms is typically under $200, with some being entirely free. However, if you are unaware of their existence, the system can absorb the funds you intended for your children, and your family will have no recourse after you are gone. Here are the 6 forms, presented in the recommended order of filing. This initial form can be the deciding factor between your children owing $20,000 or owing nothing. It is known as a transfer on death deed, often abbreviated as TOD. This document serves a singular, crucial purpose on this list. It lets you designate the individual who will inherit your home immediately upon your death, allowing the property to bypass the probate court system entirely. This is significant because the typical probate case in the United States costs a family between 3 and 7% of the estate's total value. Thus, for a house valued at $300,000, your heirs could face paying between $9,000 and $21,000 in various court, attorney, and executive fees before they can take ownership of the house. The financial cost isn't the only downside. In certain states, the probate process can last from 9 to 18 months. During this period, the house cannot be put up for sale, refinanced, or even cleared of its contents. Property taxes continue to accrue. Insurance premiums must still be covered. Any existing mortgage payments must be made. These expenses fall on your children while they wait for the court's permission to manage their own parents' home. A transfer on death deed sidesteps this entire ordeal. You file it a single time with your county recorder, and upon your death, ownership of the house transfers directly to the person you named. This means no court intervention, no legal fees, and no lengthy waiting. This form is recognized in about 30 states. You can determine if it's available in your state by searching online for Transfer on Death Deed, along with your state's name. The filing fee is generally between $20 and $60. However, the Transfer on Death Deed is effective only if filed before you pass away. Many people discover this critical detail too late. For this reason, it is not a document that should be postponed. The second form is a lesser-known document. It is called a ladybird deed. This option is currently available in only 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. If you reside in one of these states, the next minute is especially important, as this single document can shield your home from a common threat that causes significant financial hardship for many families. Here is how it operates. A ladybird deed lets you maintain full control over your home while you are alive, with the rights to sell, refinance, or rent it. Then, at the moment of your passing, the property automatically goes to the beneficiary you named on the deed. It works very similarly to a transfer on death deed, but with one vital distinction. A ladybird deed protects the home from Medicaid estate recovery. I've detailed the Medicaid 5-year look-back rule in a different video, but in essence, it means if you use long-term care Medicaid, the federal government can legally seek reimbursement after your death by forcing the sale of your house. For a common 3-year nursing home stay, this could mean the government can claim between $240,000 and $360,000 from your estate. This is a scenario where families can lose everything. The ladybird deed legally separates your home from your estate at the moment of death, leaving nothing for the government to claim. Your children can then inherit the house without any encumbrances, even if you relied on Medicaid for your last 5 years. but the Ladybird deed must be filed and officially recorded before you apply for Medicaid. If you delay, the look-back rule negates its protective power. So, if you live in one of those 5 states and own your home, this is a document to discuss with an estate attorney this month, not next year. By the time it's needed, the opportunity to use it has passed. The third document can offer substantial savings for families, more than many others on this list, but it's also where a costly error is frequently made. This is the Revocable Living Trust. Establishing a trust is more expensive than the first 2 documents, generally costing between $1,500 and $3,000 based on the attorney. But it is worth the investment for several reasons. When you place your home into a revocable living trust, ownership transfers from you to the trust on paper. You retain complete control. You can sell, refinance, or move whenever you wish. Your daily life remains unchanged. However, since the trust technically owns the home, it is not part of your estate upon your death. Therefore, it is protected from the probate process. On a $400,000 residence, this one action can save your family from $12,000 to $28,000 in probate costs. But the trust offers an even greater benefit. It provides explicit directions for how the property should be managed after you are gone. If you have 3 children, with one residing in the home while the others wish to sell, a trust can outline the exact procedure. If you want your surviving spouse to remain in the house for their lifetime before it passes to the children, a trust can facilitate that. If you aim to shield the house from a child's future divorce, a trust can provide that protection as well. A will does not offer this level of control. A will is reviewed in a courtroom, where a judge interprets what should be done. A trust remains private, bypasses the court system, and executes your precise instructions. But this is the point where people undermine the entire structure. The most costly mistake American families make with a trust is establishing one, but then failing to transfer the house into it. The correct legal term is funding the trust. If the trust is just a paper document and the house deed was never officially updated, the trust is ineffective. The house is still subject to probate. All the money you invested in setting it up goes to waste. Thus, immediately after creating a trust, your very next action should be to file a new deed that transfers the house from your name into the name of the trust. If you skip this step, the trust holds no value. We're at the halfway point, but the 5th document is coming up, and that's the one that very few people are aware of. It's the one that could save your family the most, but the time to act is very limited. Stay with me. The 4th document is an updated will containing specific language regarding your house. If you pass away without a will in the United States, your state's government will determine the distribution of your property. The legal term for this is dying intestate, and the regulations are often not what people expect. In Texas, for instance, if you pass away without a will while married, your surviving spouse inherits only 1/3 of your separate property. The remaining 2/3 are allocated to your children, even if they are from a prior marriage and have no relationship with your current spouse. In California, if you die intestate with children, your spouse receives only 1/3 or 1/2 of the community property, depending on the circumstances. In Pennsylvania, the spouse receives the first $30,000, and the remainder is divided. These intestate succession laws differ by state, but the underlying principle is consistent across all 50. The state has default rules for how your property is divided, and if you don't have a written will stating otherwise, the state's rules prevail every time. The solution is straightforward. Drafting a basic will with an attorney typically costs between $200 and $800. Some online services offer it for less than $100. But for homeowners, I advise against the cheaper online options because the language concerning real estate must be precise and specific to your state. But there's a detail many people overlook, and it's one that can cause deep family divisions. A will should be updated whenever your family circumstances change. If your will was drafted in 1992 and hasn't been reviewed since, the information it contains is likely outdated. Your spouse may have passed away. Your children may have gone through a divorce. You may have new grandchildren. The executor you appointed might no longer be living. Therefore, every will requires a review every 5 years, and also after any major life event. An outdated will can sometimes be more problematic than having no will at all, as it can lead to court battles over which version is valid. While the family disputes this, the house incurs ongoing expenses. Now we come to the fifth document. This is the one I mentioned that very few people are aware of. It's called a durable power of attorney for finances. This is the form that a vast majority of seniors do not file, and its absence can create immense stress and expense for their families. If you complete only one document after watching this video, it should be this one. Here is the reason. A durable power of attorney is the legal instrument that appoints someone you trust to manage your financial affairs if you become incapacitated. If you suffer a stroke, are diagnosed with dementia, or face a prolonged hospital stay, this document authorizes your spouse or child to pay your bills, oversee your bank accounts, and, most critically, manage all matters related to your house. Without a durable power of attorney, your family has no legal authority to perform any of these actions. They cannot access your accounts. They cannot make your mortgage payments. They can't do anything. They are forced to go to court and petition a judge to appoint a guardian or conservator. This is known as a guardianship proceeding. The average cost for this in the United States is between $3,000 and $10,000 in legal fees, just for the appointment itself. Afterward, the guardian must submit annual reports to the court, which can add another $2,000 to $4,000 in costs each year. But the financial aspect isn't the most difficult part. The most challenging part is the time involved. A guardianship proceeding typically takes 3 to 6 months to resolve in most states. During that time, no one can pay your property taxes. No one can authorize repairs for the house. No one can sell the home if you need to transition into a care facility. No one can take any action, yet the bills continue to arrive. The mortgage lender is not concerned that the family is awaiting a court order. Consequently, families lose their homes to foreclosure during guardianship proceedings every year in this country. A single document, filed on a simple Tuesday afternoon, could have stopped every one of those losses. A durable power of attorney costs between $100 and $300 to have drafted. It requires about an hour of an attorney's time, but the element that makes this so pressing is that it must be signed while you are still mentally competent to do so. The moment a physician raises questions about your capacity, that opportunity is gone forever. You cannot sign it from a hospital bed. Your children are not permitted to sign on your behalf. Once that moment has passed, the only remaining option is the courtroom, and at that point, the hardship has already begun. The sixth and final document is your Homestead Exemption filing. This is something that could be saving you money right now, today. Every single month that you don't have it is a missed opportunity. Nearly every state in the nation provides a homestead exemption for homeowners, but the specific rules and the amount of savings vary significantly from one state to another. In Florida, the exemption can reduce your home's assessed value by up to $50,000 for property tax calculations. It also limits how much your property taxes can rise annually, regardless of your home's increase in value. In Texas, as of 2024, the exemption takes a $100,000 off your home's assessed value for school district taxes. The annual savings differ by state, but for most senior homeowners, the benefit is between $1,000 and $3,000 per year. Over a 20-year retirement, that amounts to between $20,000 and $60,000 that stays in your pocket, instead of going to the state government. But this is what many seniors don't know. In a lot of states, the homestead exemption is not granted automatically. You are required to submit an application to your county tax assessor's office, and you only need to complete this process once. From then on, the exemption remains active for as long as you own the home. The application is typically free and can be completed in about 15 minutes. Many states also provide extra senior exemptions on top of the standard homestead exemption, which become available in the year you turn 65. These can add another $5,000 to $15,000 in tax savings over your lifetime. Many people who are eligible for the senior exemption don't apply for it, because the county does not typically mail you a notice to inform you of its existence. You have to know that you should ask, and now you do. Here is your plan for this week. First, locate the deed to your house. It should be in your filing cabinet, a safe deposit box, or accessible through your county recorder's online portal. Second, make a list of which of these 6 documents you currently have and which ones are missing. Third, for any document you're lacking, search online for the document's name followed by the name of your state. Review the first few search results. Fourth, contact an estate attorney in your county and schedule a 1-hour consultation focused on home protection documents. This will likely cost between $200 and $400. The attorney will advise you on which of the 6 documents are necessary for you, based on your state's laws, your family's circumstances, and your home's value. Fifth, act promptly. Each of these documents has a window of opportunity, and each of those windows closes the instant something happens to you. Once you are hospitalized, once the court is involved, once the state intervenes, the opportunity to use these tools may be lost.